course, this story is still one that has the community of Fleurhof as well as the South African public still reeling following, of course, that particular judgment in court today. The Roodepoort Magistrates Court denying bail to 31-year-old Tiffany Meek, who is charged with the murder of her 11-year-old son, Jaden Lee Meek. Now, let's bring in legal analyst Elton Hart to make sense of this judgment. Elton, a very good afternoon to you. Thank you so much for your time. So what do you make of the judgment? And perhaps walk us through, Elton, what the court relied on to make its decision. We heard, of course, outside court, Tiffany Meek's defense lawyer, Anova Naidu, saying that the accused believes this is not the end of the road for her.
No, indeed. Because remember now, I think people tend to confuse bail with punishment. And to think that if you deny a person bail, you're actually punishing them for the crime. But that is not the case. The thing of the bail mechanism was designed to see if a person will stand trial or not, will interfere with the witnesses or not. And I think the magistrate here, in this case, put a lot of emphasis that Tiffany Meek can't stay at her current address in Fleurhof. She has to now relocate to somewhere in Verulam, and they put a lot of weight attached to that. And I don't think that you should make that one factor outweighs the other. And the thing is, like with bail, it's not about is this person guilty of committing the offense or not. It's just to see, will they interfere with the justice system, the investigation, the witnesses, and will they come to court? That's basically what the inquiry is about. And also, she also mentioned that the state's case looks like sort of half good against the accused person. Even if that's the case, it doesn't mean that it should be an overriding factor. So what the lawyer was saying, Mr. Naidu, he was pointing out to say that he doesn't feel that the magistrate sort of applied the mind correctly to the set of facts before. He feels that if this set of facts is presented to another court will come to a different conclusion, and hence they can appeal the bail decision and take it to a higher court for them to decide on the faith pertaining to bail. Or if there's new and additional information of Tiffany Meek that comes to light that they might find, they can also bring a bail application before a different magistrate on totally new facts. So that is what he was sort of half addressing the media on.
Yeah, I'm going to come back to Mr. Naidu's points and perhaps if you can just give us the scenarios there. But I want to stay with the state for a while. State opposed the bail for Tiffany Meek, based, of course, on concerns that she may tamper too with evidence or influence witnesses, citing those incomplete investigations and the forensic reporting. What standards of proof and perhaps legal principles guide these bail decisions, especially when evidence and forensic analysis is still pending?
No, the thing is the investigation can continue. What the court can do for the court to protect the integrity of the system is to set bail conditions for the accused person, to say that she cannot speak directly or indirectly to state witnesses. She cannot come to the crime scene. They can set certain conditions. So that's a way. There's a way that you can actually sort of manage the accused person in a sense with the bail conditions that's available. Because if she goes to the crime scene, then automatically it's a violation of a bail condition and she can then be transported to jail and her bail be withdrawn. So there is mechanisms at the disposal of the state. But if you deny a person in anticipation that they are guilty and not having heard and having seen all the evidence, that is already technically sort of tantamount to punishing that person for a crime that is alleged against that person. So what Mr. Naidu was actually alluding to is to say that the magistrate, and he's of the view that the magistrate did not take everything globally into consideration in coming to the conclusion to say that she is a person that will interfere with the witnesses. She's a flight risk. She will endanger public safety and those type of things, because there's a whole host of things that is mentioned in Section 60, subsection 4A to E that you have to read in conjunction with Section 60, subsection 5 to 8 when making that bail decision. So it's not about is this person guilty or not, but more or less, will the person stand trial and will the justice system not be affected if that person is released?
Yeah, and just going back to what we heard in court during the bail application itself, I mean, the defense counsel, Mr. Naidu, pointing out inconsistencies and gaps in the state's case, for example, the absence of eyewitness testimony, also talking about conflicting claims, timelines, and a disputed alibi. I mean, to what extent may these inconsistencies meaningfully affect the outcome of the bail ruling versus the eventual trial? I'm noting, of course, that Meek was denied bail in this case.
The thing is, like, when we look at it, and that things that's inconsistent in the statements and things that was said, it should not be actually one of the overriding things. Bail is strict. There's guidelines as to what you look at bail. If you talk about the merits of the case, then that's something different. You have to deal with that at trial. You can most probably say that the state has got a weak case in showing the discrepancies and the weaknesses in the state's case, but that's as far as it goes. You cannot now say because there's a witness that's saying X, Y, and Z, and there's no state or an eyewitness that saw what really transpired. That is issues for the trial court to decide. So the bail court should not be seized with that. And I heard there was like some mention of this, and I don't know how much it weighed in until I see the judge's reasons for denying the bail. Then I can make out more out of that. But I don't know how much weight the magistrate actually attached to the fact that there is certain evidence that the state feel that they've got a strong case. Although there's a strong case, it should be like one of the factors. It should not be the overriding factor.
Very quickly, Elton, as we wrap our conversation, we said, of course, that Naidu says that they still have an option, to bring another bail application on new facts or appeal to the magistrate. What are his prospects?
No, it depends on. I think as with bail, you can appeal it. I mean, if you go look at the Nandipa Magudumana case or scenario, where the magistrates court denied them bail and then they approached the High Court granted them bail. And we know the amount of intricacies that's in that case. Here's the similar scenario. So I think one always has a chance. There's 50-50 that a higher court might come and say, listen, looking at the bail legislation, which is captured in Section 60 of the Criminal Procedure Act, I think that if you look at all these factors, this person qualifies for bail. We saw with the Mitchell's Plain case yesterday that the lady got 4,000 Rand bail. So it's not unlikely, but they have to also weigh it up against the public concerns surrounding this case, and the public interest in this case. And I think there's always a chance to get bail on appeal.
All right, Elton, thank you so much for your analysis. Really do appreciate it. Elton Hart, legal expert there for us.